Good morning, everyone, and thank you for joining us for today's commercial law webinar. Today's webinar is being given by myself, Poppy Rimington-Pounder, Shantanu Majumdar QC, and Josh Lewison. We've all seen a lot of articles and webinars over the past few months about frustration and force majeure, but the focus of our webinar today is on collaboration. We will be looking not at how parties can get out of their contracts, but at how they can seek to maintain them, and in doing so, maintain their commercial relationships. I will first be discussing why parties should seek to collaborate with their commercial counterparties and what legal effect any subsequent agreements might have on their contracts. Then Shantanu will be telling us about how these parties can use mediation to agree and negotiate these formal variations. And finally, Josh will be considering what impact this might have upon directors' duties and any subsequent insolvency. So, why should businesses take a collaborative approach with their commercial counterparties during a time of crisis when it might be possible to get out of their contracts and avoid their obligations? It might be better for your business in the long run if you seek to collaborate. It will also help preserve and foster your commercial relationships. It will be better for your employees of the business and the wider economy, and it will probably help preserve your reputation. It also may well avoid costly litigation, pleading frustration, force majeure, or breach. So when your commercial counterparty falls into breach, you could sit back and do nothing and ignore the breach. Likewise, if you are the party in breach, you could simply hope that your commercial counterparty doesn't do anything. But the problem with that approach is the uncertainty. The party in breach doesn't know the other side's reaction, and the party who is not in breach doesn't know what is happening and how long this will last, and no doubt will start to feel rather less inclined towards the other party. The best course is to contact that commercial party as soon as possible. So once you have contacted that other party, what legal effect would this have on any agreement that you come to? We are all familiar with the doctrine of promissory estoppel, and I've referred there to two of the leading cases. That's Hughes and Metropolitan Railway Company, and also Central London Property Trust and Hightrees House, the famous Denning case. The essential ingredients of promissory estoppel is that there must be a legal relationship between the parties, giving rise to rights and duties between them. There must also be a promise or a representation by one party that he will not enforce against the other his strict legal rights arising out of that relationship. There must be an intention on the part of the promising or representing party that the latter will rely on that representation. The latter party must rely on that representation. And finally, and crucially, it must be inequitable for the first party to go back on his promise. Often the doctrine of promissory estoppel is described as being suspensive of rights. However, it can also be extinctive. I've referred there to the case of Virolite and Virolite distribution, which describes circumstances in which the doctrine might become extinctive. As you can see there, it says the determinative consideration is whether it is inequitable in all the circumstances for the representor to enforce his rights inconsistently with his representation. Those considerations and the circumstances will include the precise terms of the representation, how the representee has responded to the representation, and whether it remains possible for the representee to comply with his original obligation. So, although it is generally suspensive, it may well extinguish rights altogether. If it merely defers a party's obligation, say to pay rent, then what might be a reasonable time for that party later to comply? In the Hughes and Metropolitan Railway Company case, it was held that 6 months was a reasonable time for the parties to comply on the particular circumstances of that case. But as we can see from what's just been said, relying on promissory estoppel may well leave parties uncertain as to their rights. Is what has been agreed going to be extinctive of rights or merely suspensive? if suspensive, what might be a reasonable time then to repay? The other doctrine which I'm going to talk about is waiver. This is quite similar to promissory estoppel, and it's where a party agrees to a request that it will not insist on its strict performance of a contract according to its terms, or makes a representation that it will not. And so strict performance in accordance with those terms is waived. Similarly to the generally suspensive nature of promissory estoppel, a waiver can generally be retracted on reasonable notice, but it can become irrevocable, and this will frequently depend on subsequent events. I've referred there to the case of Bottiglieri. Normally, however, reasonable notice will have to be given. Whether it's revocable, this will depend again on the circumstances. If, for example, goods have been delivered late following the receiving party's waiver, then that party cannot later reject the goods and demand strict performance. It will simply be too late. It should also be noted that commercial contracts will often exclude or restrict waiver. So again, as with promissory estoppel, relying on waiver may well give rise to uncertainty. Does the main contract exclude or restrict waiver? Is the other party going to retract its waiver? Or has the waiver become irrevocable? The best course for parties is to agree a formal variation so that both parties, or all the parties, will know where they stand. Any variation should be in writing. This provides firm evidence of what the parties have agreed, and many commercial contracts will include a no oral modification clause. As we know from the Supreme case of Rock Advertising, those will be upheld. Any variation must also be supported by consideration or executed as a deed. I've set out some of the key considerations for any formal variation. So is this subsequent agreement going to be a permanent or a temporary modification of the parties' rights, as we've seen with the doctrines of promissory estoppel and waiver? If it's a temporary modification, what is going to bring this to an end? What rights are being modified? How are they being modified? What is the other party going to get in return? And are there any other terms in the contract that will need to be changed accordingly to reflect this variation, or in any other contracts that it might have a knock-on effect? So those are all matters that will need to be considered. But how will you negotiate your formal variation with the other side? Well, at this point, Shantanu is going to tell us more about how commercial parties can use mediation to agree these formal variations to their contracts.
Poppy was partly right when she said that I was going to talk about mediation, and it's not her fault that she's only partly right. And the reason for that is that what I thought I might do, and Poppy's hinted at this, is talk about what I would describe, or I might describe as, the wider context. When she's explained to us various familiar, or perhaps not so familiar, legal concepts which might inform the way that parties try to solve their contractual disputes in these unusual times. But there are hints in lots of places, including the things she said, about other reasons for doing it, ways to behave, ways to be seen to be behaving, which seem to me to impact on this question about what you should do with your disputes before you even come to mediate them. Some of you may have seen back in April that there was published something called a concept note called Breathing Space by the British Institute of International and Comparative Law. Amongst its authors were Lord Phillips and Lord Neuberger, so two former presidents of the Supreme Court. And one of the phrases in that very short document, there's been a more expanded version which was published last month, which certainly caught my attention, was this: an outcome which leaves one party a winner and the other a loser will not take full account of the market, social, to contextualization of the crisis. Now, reading beyond or below the jargon, that seems to me to be a very good way of describing the situation in which quite a lot of businesses are going to find themselves. I think the reference to market contextualization was specifically a reference to what Mario Draghi, the former president of the ECB, said in the FT back in March, when he was talking about a plethora of defaults leaving irreversible damage. And his particular concern that he identified in that article was the implications of default in complex international supply chains. Now, the phrase supply chains has become very perhaps familiar, perhaps too familiar to us in the context of Brexit discussions. But of course, we're familiar with them more widely in the globalized world of trade that has grown up over the past few decades. And one of the obvious dangers that Draghi identifies, and some of us have already seen some examples of that, is that a dispute which blows up from the particular contract in which it blows up will just be a matter of timing and chance, will trigger a series of defaults, potentially across many jurisdictions. Now, some jurisdictions have enacted legislation giving temporary relief to particular businesses and individuals who aren't able to fulfill their contractual obligations. But in this country, there's been very limited action from that perspective, and we know about changes to the ability of parties to bring possession proceedings, and of course the proposed changes to corporate insolvency law, in particular COVID aspects to that. Countries such as Germany, Singapore and France have gone much further and have enacted statutory breathing space moratoria in relation to more general contractual obligations. But here, the government has only issued guidance. So some of you, well, and there are two documents in particular that I was thinking of. One is better known perhaps than the other. Both were issued on the 7th of May. And the first is rather snappily entitled Guidance on Responsible Contractual Behaviour in the Performance and Enforcement of Contracts Impacted by the COVID-19 Emergency, the language of Shakespeare. More directly targeted at the construction industry was a simultaneous guidance note called Contractual Best Practice Guidance. And I think what this had in mind was that in a lot of construction contracts, and of course there will be webs of construction contracts, there will very often be very specific, very detailed and often quite rigid dispute resolution mechanisms. And what the contractual best practice guidance says is that notwithstanding the contractual provisions, employers and suppliers should seek to take a collaborative approach towards successful project delivery and discuss whether an extension of time can be granted and any additional costs shared in any event. Now, this is clearly a novel area, because in one sense, what the government is doing, or perhaps this is the only sense in which this guidance perhaps can be understood, is it's encouraging people not to exercise their strict legal rights. And one might even go further and say it's even suggesting or hinting at disapproval of what is ostensibly lawful conduct. Now, you might say, as frankly I said, or certainly thought on the 7th of May and for some time thereafter, that this is all very interesting, but that guidance which is not expressly legal enforceable is just a collection of words, and it doesn't really have any effect on what our clients should do and how they should behave and how we should advise them to behave. Now, it's certainly difficult to see how the courts can take the guidance into account, except perhaps in relation to their attitude to the efforts which the parties have made to mediate. It may be that in a COVID context, if I can put it like that, the courts will expect even more when it comes to consideration and the implementation of alternative dispute resolution methods. But I think beyond that, we are all detecting a change in public expectation about how private businesses should behave. And that seems to me to be particularly true if those businesses have been the beneficiaries of public funds. And that, of course, they might have been beneficiaries in a number of ways, furlough payments perhaps being the most obvious and most widespread one. But one's thinking also of grants and government-backed loans. And one only needs to cast one's eye over newspaper articles in the past 2 or 3 weeks to see the level of public opprobrium which has been initiated or certainly stoked by Richard Branson, for example, a billionaire to the tune of however many billions, asking for bailout funds for Virgin Atlantic, or businesses such as BA, which have been criticised for taking taxpayer money to make furlough payments, only then to propose making large swathes of their workforce redundant. Now, these are headline examples, but they illustrate what seems to me a much wider trend. And I think it's not too much to say that it may limit the options of our clients in a way which perhaps gives a kind of moral and practical force to what the guidance merely recommends. So far as the courts are concerned, I mean, the specific message has been fairly clear. The Lord Chief Justice on the 19th of March, so as early as the 19th of March, commended mediation as a means of resolving disputes. And just a few weeks later, and I think this was in the context of the concept note, which I mentioned earlier, which Lord Neuberger was one of the authors, he referred to the legal world having a duty to the rest of the world to prepare itself, and went on to hint, at least, maybe even suggest, that mediation should perhaps become compulsory in this jurisdiction. That's something that's often discussed. It's happened in a number of other countries. Maybe it'll happen here. It hasn't happened yet. But putting on one side what you may think about a service, court service, whose sole role is to decide disputes, urging us yet again to avoid using it, nobody doubts the potential commercial benefits of settlement over litigation or arbitration. And one of the particular things that comes out of the crisis, which might encourage people to consider other means, is the inevitability of the delay in the resolution of disputes. Certainly once it got up and running, the Business and Property Courts certainly claims to have done 80% of its usual workload. Other courts have done rather less well, and it varies between areas and jurisdictions. But even at 80%, this means that there's going to be a backlog and thus longer than usual delays. And that ought, it seems to me, to provide an additional impetus to settlement, particularly if the consequence of many of the disputes in which our clients are going to be involved will have immediate cash flow considerations, which make delays in the resolution of legal disputes by the courts impractical. Now, all of this, as I say, ought to give an additional impetus to settlement. And practically speaking, that will usually mean mediation. And I don't, by saying that, mean to dismiss other ways of dealing with things. And there's been some suggestion that early neutral evaluation, which has long been available, but is hardly ever used, might play a more significant role. I'm not so sure about that, and maybe that's something we can discuss if anyone's interested in it. But mediation seems to me to be the obvious way forward in doing what is in business's interest, but also doing what business, I think, for the reasons I've given, are expected to do in the current situation. Mediation, because, let's face it, if parties or their solicitors were very good at settling disputes by just picking up the phone, then mediation wouldn't already be so popular, so successful, and indeed necessary. So what does mediation have to offer in COVID disputes? Now, I'm not going to pretend to have any sparkling insights in this context, because for the obvious reason that most of the existing strengths of mediation are precisely why it's also useful for disputes which arise from the inability to perform contracts because of COVID restrictions and economic effects, etc. But what I've done is, and I hope it's not too banal, is to collect a few thoughts from my own kind of experience about how mediation might work in this particular context. And the first, I suppose, is this, is that I think what any good mediator always does is to help the parties to identify interests which underlie and maybe even seem to run counter to the often rather binary and adversarial stances taken in their position statements. Now, as you've heard and as you will hear in this webinar, we have been encouraging people to take a rather broader outlook than the mere legalities of a particular dispute. And that involves, I think, enlarging the focus on from the specific dispute to encompass longer term relationships. And as I've already said more than once, the importance and advantage of being seen to do the right thing. And I see mediation as playing a potentially crucial role in that process because it provides the space, it provides the presence of the parties, of course, and it provides the mediator input to allow that to happen. Now, one of the great strengths of mediation is its adaptability, as well as providing the means by which the parties can agree things, perhaps with a degree of mediatory encouragement, which the court has no power to order. Now, one of the many things that mediators are trained not to do is to make suggestions to the parties about solutions. And I think rather like the golden rule about not asking questions you don't know the answer to in cross-examination, whether or not making suggestions, if you're a mediator, is the right thing to do depends. But I think we all know that although officially and technically and maybe superficially, it's for the parties to come to their own conclusions about what the right course is. Mediators play a very important role in making timely and careful suggestions to the parties. And I can see a particular role for that in the current environment, because I think people are going to need to be encouraged to think beyond the things that people normally come to mediations to argue about and discuss and to negotiate. That's stepping back, considering the wider context, considering the possibilities of collaboration and compromise in a way that takes account of, as I say, the very unusual circumstances in which we find ourselves. Now that might mean that there is more mediator engagement before the mediation than one's currently used to. Might involve, for example, an earlier exchange of position statements. I mean, sometimes that happens already, but one is also familiar with getting them sometimes the day before, whatever the mediator has asked. It may be that these will be cases where it is for the mediator, having had perhaps a bit more time to look at the position statements, will want to talk to the parties and in advance of the mediation, try to encourage them to think about certain things so that on the day, they are in a more advantageous place to having these kind of wider discussions, which might be necessary in resolving these sorts of dispute. Now, in doing that, a mediator is going to have to take a special care not to descend into the arena and to maintain neutrality. And I see no reason why that can't be done. It's just a question of the way that you do it. Another thing that mediation is ideally suited to accommodate is multi-party mediations. And I was thinking in this context of this sort of situation, and it's obviously going to be a very typical one, and that is where if you suppose a sale or a supply of goods situation, I've already mentioned complex supply chains, there will be a legal relationship with an onward buyer or an underlying seller, which is economically, if not contractually inextricable from the immediate dispute. Now, a creative and or a longer term solution might well benefit from or even require the participation of those third parties. And that doesn't necessarily mean that those people have to be represented or present, but certainly contact having been made with them and perhaps their availability during the mediation discussions which take place on the day. Now, we're not unfamiliar with those sorts of situations, and they can be hard enough where the onward contract or the underlying supply contract is subject to English law. I mean, that can be difficult enough, but at least the same general law is applicable. But I recently had to look at a situation where the immediate dispute is subject to English law, but the supplier had contracted with a company in France, rather inconveniently under French law. And if one thinks about the force majeure and frustration considerations that immediately become potentially relevant in these disputes, you can see that that's a very serious complication, which again might well lend itself to mediation and the sorts of dispute resolution that can offer rather than litigation. What about plenary sessions? Just thinking about how mediations take place on the day. Now, mediators are always in favour of them. Parties' attitudes vary. Quite often, parties' lawyers will often just want to get on with the negotiations, but I think one can immediately see that plenary sessions might have a particularly valuable role in a situation where the whole premise really, or the whole scope really for settlement comes from people having a discussion about things that they would perhaps ordinarily not have thought about, let even talked about. And so I think that's one of the structural considerations that one might want to bear in mind in terms of the way the mediation is run on the day. I can't, for obvious reasons, finish with this subject without saying something about virtual mediation. Quite a lot of mediations have taken place over the past few months in circumstances where physical attendance has not, of course, been possible. My own view about that is that it has been surprisingly successful. But it's probably more a question of those mediations having achieved settlement in spite of, rather than because of, the electronic medium. And I think, rather like virtual court hearings, it's surprising when you have to do something, how much you realise it can work. And I think, again, like virtual court hearings, there will be no going back, and I suspect that there will be a permanent role for virtual mediations in the future, even once it becomes possible, and who knows when quite that will be, for physical mediations to take place in the way that we're familiar with. But it doesn't seem to me that virtual mediations provide any obstacle, or indeed provide any particular advantages when it comes to mediating the sorts of dispute that we're talking about. So that's all I'm going to say at the moment, except perhaps just to mention very briefly the interdicted subject of force majeure and frustration. One of the many reasons we decided not to talk about it is that it's a subject that's been done to death by other solicitors and barristers. I've also took the view at an early stage that it was actually unlikely to be helpful to most people in their disputes, and certainly that's been my admittedly anecdotal experience and the things that I've been sent to look at. But one can see that having force majeure or frustration, at least as a potential argument, in a mediation context, might give some parties, and it'll depend on the facts, a bargaining counter in a situation where, at least in terms of strictly enforceable legal rights, one person is going to be the loser and the other person is going to be the winner. And that seems to me to be a big disadvantage of something like early neutral evaluation, which has been suggested as a way of cutting through the arguments that one might have very lengthily and very expensively in long court cases about whether you can plead frustration or whether this force majeure clause is applicable. Don't go very far down that route, but it may have a role to play when it comes as a kind of bargaining counter in the context of a mediation. Anyway, I've said probably too much about force majeure and frustration. And I'm now going to hand on to Josh, who's going to take up the narrative, as it were, a settlement at mediation having been assumed. And he's going to discuss how that fits in with how directors in particular can reconcile what they have agreed with their duties to the company and to others. Josh.
Shantanu, thanks very much. Yes, I'm going to focus on how we navigate the company law and insolvency law framework, particularly where a company may have strict legal rights that are quite clear cut. And the company then decides not to enforce those or to take a more relaxed approach to performance of a contract, and how that might fit in with that framework and the opportunities and risks that are out there. So hopefully I should be able to share some slides with you. When we look at a company and company governance in particular, there are really three interest groups. First of all, there's the shareholders who have the primary interest in the company. Ultimately, they are the beneficial owners of the company, so they get the benefit of the capital value, and they get the benefit of any income that the company might produce. They also have a secondary interest on winding up, although my experience of most insolvencies is that by that stage, the shareholders don't have any interest at all. Next, there are the stakeholders, by which I mean really the employees, the suppliers, the wider community in which the company might be doing business. And as we'll see, directors have to have regard to them. And finally, there are the creditors. Now, most of the time, of course, creditors are just stakeholders. They do business with the company and they hope to be paid. But where the company is or is likely to become insolvent, the creditors actually have a primary interest that replaces that of the shareholders. So when a company is deciding on how it's going to carry on business and how it's going to do deals where the performance of its contracts may have become much more difficult, all these interests have to be balanced, but they have to be balanced in quite different ways. The primary duty that we're looking at is the one that arises under section 172 of the Companies Act 2006. And this is the duty to act so as to promote the success of the company. The first thing to remind ourselves of course, is that this duty is one that's owed to the company. So although there are these three interest groups out there, no actual direct duty is owed to them. They have an interest in the success of the company, but that doesn't correlate with any duty owed to them by the directors. The section is built around a concept of success, which isn't further defined. And in a sense, it's for each individual company to decide what success means. But the primary duty is encapsulated in the first part of the section, which provides that the success of the company has to be promoted for the benefit of its members as a whole. So that's a direct primary duty. But in doing that, the section goes on to say that in doing that, the directors have to have regard to various interests. And the ones that I think we're probably most interested in at the moment are the employees, business relationships with suppliers, customers, and others, community and environment, and the company's reputation for high standards of business conduct. And really, I think that's where that last one, high standards of business conduct, is where the government guidance about responsible contractual practices fits in. Finally, the section has a carve-out for other rules of law that require directors to consider or act in the interests of creditors of the company. And we'll come on to that a little bit later. But first, what I wanted to do is think a little bit about what success actually means, particularly in this context where there's been huge disruption to business and supply chains. So at the moment, one could see that for the shareholders of the company, success at the moment might just be survival. Can the company keep going until such a time as normal conditions, as close to normal as we can get, can be resumed? Other successes for shareholders might look like getting a dividend out of the company, and it might be an increase or at least preservation of capital value. But thinking about dividends for a moment, I think that sort of reflects back into the other matters to which companies have regard, and something that Shantanu was saying about some of the attention that certain big companies have had in the context of dividends. And in particular, you may remember that shortly before the various government schemes to help businesses keep going were announced, EasyJet declared a huge dividend and paid it out to its shareholders. Now, the shareholders might well have been thinking that this was a terrific thing for them. But as a long-term matter for the company, one can certainly see that the reputation of EasyJet has suffered as a result of having done that. For the stakeholders of the company, so the suppliers and the employees and others, they may not be concerned overly with whether the company is even profitable, let alone successful in a commercial sense, so that workers may wish to be treated fairly. Commercial counterparts may wish to be treated decently as well, so that one can, for example, think about other companies, and I was thinking in particular about the Trump Organization, so that Donald Trump has a reputation, very largely deserved it seems to me, for doing the dirty on his suppliers, architects and others when he builds his extremely ugly buildings. Now, he does certainly have a lot of money, whether as much as he claims to is perhaps another question. But how many people wish to do business with him if that's the way in which he commercially operates? And that's even before we get on to what his values might be. As I said, for the creditors, success probably just means getting paid. But if the company does become insolvent, then success for them will be minimizing the losses that they suffer. So how then do directors go about making decisions safely so as to avoid a breach of their duties? I think the first point of real comfort for directors is that it's a good faith test, which is essentially subjective. So if the directors honestly believe that they are making the decision to promote the interests of the company, then theoretically, at least, they should be in the clear. I say theoretically because, of course, there are some limits. The section specifies certain matters to which the directors must have regard, but does that really mean that they can have regard to those at the expense, say, of the interests of the members of the company? There are also limits perhaps on what the scope of reasonable decisions might look like, so that if there were a dispute later on about a decision that directors made, then probably the more extraordinary the decision, the more extraordinary grounds would have to be given in order for the directors to show that it had been made in good faith. And the directors may also find themselves making decisions in good faith that might nonetheless offend the statutory duty of care further on in the Companies Act. But the question of stakeholder interests is one that's been lightly, if frequently, trafficked. I think political parties of all stripes have canvassed the idea of having stakeholders on the board of companies. So that might include representatives of workers or just ordinary employees who participate in decisions. But so far, that's not yet come to pass. More interesting, I think, is the government guidance. And I think the government guidance on contractual practices, certainly at this time, is one that does have quite a lot of impact on the way in which directors are to have regard to the interests of people other than the shareholders. So that where the guidance speaks about the treatment of suppliers, the treatment of workers, whether companies insist on their strict rights, which might disrupt the economy, I think that is something that directors can very fairly and squarely take into account under the list of matters set out in section 172. But then we get on to the question of creditors, who are much more likely to be nakedly commercial in the way that they approach their interests. And so what I wanted to do is just look at how that framework sweeps in. Now, at the worst possible time, the law is unsettled in this area. The leading case on creditors' interests is a case called BTI 2014 in Sequana. It's a decision of the Court of Appeal so far. Argument in the Supreme Court has already happened, and a decision of the Supreme Court is awaited. And the question, or one of the questions at the heart of BTI and Sequana, is when is it that the primary duty of the directors switches from being promoting the success of the company for the benefit of members, and when it switches from that to promoting the success of the company for the benefit of creditors. And a number of options were canvassed, each of which finds some support in the case law. So one option was when the company actually is insolvent. Another option was when the company is on the verge of insolvency. And the third one, which is what the Court of Appeal plumped for, was when the company is or is likely to become insolvent. So the scope of those potential options is at the moment up for debate. The Court of Appeal's essential reasoning was that the company is actually insolvent is too narrow. And when the company is on the verge of insolvency, it creates, using that phrase creates perhaps an inaccurate sense of immediacy, whereas in fact companies can be on the verge of insolvency for a very long time before some cataclysm finally pushes them over the brink. It's a common thread throughout the case law that at this point, the creditor's interests become paramount, quote unquote. It's not quite clear what the courts mean when they say paramount. Certainly, we can say that the shareholders' interest in the company is displaced by that of creditors. But what is much less clear is whether during the time when creditors' interests are paramount, directors are still either required or entitled to take into account other interests as well. Looking at the starkest contrast between the two, if there is a company of doubtful solvency, such that the directors think that the creditors' interests have become paramount, does that mean that they don't consider the shareholders at all, or do they consider the shareholders as a sort of species of creditor who will take any surplus on a winding up, or do they see the shareholders as being people who will benefit in the event that the company can return to solvency? Difficult questions that so far have not been satisfactorily answered. There are also remedies that the company may be facing under the Insolvency Act. So wrongful trading has had a lot of attention recently because the government has purported at least to take wrongful trading off the table, so that section 214 of the Insolvency Act has been partially suspended, or at least it will be if the Corporate Governance and Insolvency Bill goes through Parliament and gets the royal assent, which it's anticipated it will do this week. But does that mean that all claims relating to wrongful trading have gone? I don't think it does, because what we're talking about in a wrongful trading scenario is that the companies know, or ought to know, that the company cannot avoid an insolvent liquidation, but nonetheless they go on to fritter away the company's assets. In those circumstances, it's quite difficult to see why there wouldn't also be a breach of the director's duties to the company, even if the availability of the wrongful trading claim has been removed. But perhaps of more interest for companies that are deciding not to insist on their strict legal rights is how that interacts with the remedy for transactions and undervalue. So under section 238 of the Insolvency Act, where a company receives no consideration or consideration worth substantially less than the consideration that the company gives, there's a claim against the directors. Now the defences are based on, it's a sort of composite defence based on both good faith and reasonableness, so that the defence is that the directors believe in good faith, the company entered into the transaction, did so in good faith for the purpose of carrying on its business, so that's the good faith element, and that at the time there were reasonable grounds for believing that the transaction would benefit the company, so a more objective test on the benefits side. Now, when we think about the current situation, in particular in the light of government guidance, what we need to think about is how directors can form a view in good faith that not insisting on their strict legal rights is for the benefit of the business and for the benefit of the company. So once again, it takes us back to the question I looked at at the beginning, which is what is success and what is benefit? What do they mean to us? And it seems to me that certainly under current circumstances, I think companies are being encouraged by the government at least to take a much broader view than simply the central commercial financial interest of the business. So I think that's probably all I can really say about the law. I mean, every case will be fact specific, and when a company does a deal in the manner envisaged by Shantanu, there is a framework that has to be navigated, but I think it can be navigated. I think the seeds are all there, and in the fullness of time, I think companies will find themselves much more adept, considering much more long-term and much softer elements of their commercial dealings. So what I'm going to do now is hand back to Shantanu, who in his silky way will draw together the threads and perhaps give us some final thoughts. Shantanu.
Yes, well, the spotlight is back on me. I was interested in what Josh was saying. I was interested in what Poppy had to say, less interested in what I had to say. And I think that what Josh was talking about is an inevitably nebulous and therefore interesting, but also therefore difficult area. And I suppose that I'm interested to know, Josh and Poppy, what you think about this. I mean, people are being encouraged, I think, in that guidance, implicitly, if not explicitly, to decide on how to behave in relation to their contractual disputes in a way that somehow takes account of the interests of the wider economy. But I mean, no one is going to be able to come to court if it comes to that. And, for example, try to invoke a good faith defence, or try to seek the benefit of section, or say that it's fulfilled its duties under section 172 by saying, we took less money because we thought it would benefit the wider economy. And that much seems to me to be obvious. But in a way, at the same time, and there seems to me to be a tension, that is to some extent what people are being encouraged to do. I mean, how is that tension to be resolved?
Well, I think really it comes down to looking again at what the success of that company will mean. Clearly, there has to be something tangible there. I agree that the wider benefit of the economy is probably not enough. But one can certainly see that directors could form a view that if they are seen to be cooperative with their suppliers, perhaps let's consider a more concrete example, which might be a landlord who agrees to forego part of the rent, so a bit like the High Trees House case that Poppy talked about. There's no immediate benefit to the landlord from doing that. But if the landlord then garners a reputation for straightforward, fair, honest and generous commercial dealings, one can see that that might be of substantial benefit to the landlord in the future, provided, of course, that the directors think that the company can survive that long. And really, I think that's the tension. If the company is going to be put at risk by doing this, it's much more difficult to say, well, we thought in good faith that this would be for the benefit of the company. But if the company can survive, I think the directors are perfectly entitled to take a long-term view, even if it means perhaps damaging their more short-term interests.
Yes, I can see that. I mean, the life and death situations, I think, admit of only one result when you have an option. But yes, it's the grey area where you can, I suppose, spin it, and there's going to be an element of that. It's going to be a step further back from that. Yes, I mean, it's interesting. I touched on, didn't I, and you expanded upon the extent to which our clients' freedom of action in their commercial dealings may be restricted by the fact that they've been recipients of, in many cases, rather generous grants of public money. And I was thinking of it as much in the specific context of enforcing contracts. You expanded it, I thought helpfully and interestingly, to talk about dividends, but it might even impact on things like the raising of prices, which might be an obvious response to poor cash flow and lost profits during the lockdown. But yet again, maybe yet another thing that businesses may find it difficult to be seen to be doing, at least very immediately. I mean, what I think all of this raises, and I think I referred earlier to Lord Neuberger saying to the Today programme that, and I just find the words again, the legal world has a duty to the rest of the world to prepare itself, he says in rather apocalyptic terms. But I think one of the things that strikes me, having suddenly listened to Poppy and to Josh and thinking about some of the things that I've been talking about, is that what this to some extent suggests is, I mean, at one level, we're lawyers, we advise about the law, it's for our clients to decide for themselves where their commercial interests lie. But we do seem, at least potentially to me, to have entered into a slightly different territory where our roles as legal advisors may inevitably involve giving kind of wider commercial advice than we're used to, along the lines of the sorts of things we've been saying. And of course, it's going to be a central role, in my view, in the sorts of mediations that people are being encouraged to take part in order to settle their disputes. Now, we've encouraged people to ask questions, but I'm taking the view that people are so bamboozled, particularly by what I said, to be struck dumb. But what I hope we've done, certainly what we've aimed to do, is to provide a sort of coherent, chronological, if you like, narrative, which has aimed to take a fresh view. I mean, everyone who thinks that they're being original is almost always wrong. But what we certainly feel we have done is not told you what lots of other people have told you about the most obvious responses to breakdowns in contractual relationships. And we certainly will feel gratified if any of you have taken even one or two ideas from what we've said, which might be of benefit in the cases on which you were called upon to advise. Now, having said there were no questions, and I'll read it. Hi, Josh. Great presentation, thank you. Do you think the COVID lockdown will cause the Supreme Court to rethink where it may have been going with its consideration of sequana? Josh, what do you think about that?
Oh gosh, it's a good question. I suspect that none of us really knows what goes on. Well, I certainly never know what goes on in judges' minds, even when I'm talking to them, let alone when I'm finished talking to them. I mean, really, I suppose that the anterior question is whether the impact of the pandemic makes any impact on what directors know or should know about the health of their companies. And I think it undoubtedly does. And quite apart from nobody knowing really how this situation is going to unfold, there's a second dimension, which is nobody really knows what the government might do from one day to the next, whether in the form of planned responses or in terms of U-turns. So if the current test is that the company is or is likely to become insolvent, in a sense, is insolvent is a fair, bright line test. But I mean, how can one possibly judge whether a company is likely to become insolvent when there is every possibility of further government assistance being made available, or indeed further setbacks in the fight against the virus that may mean that the situation deteriorates really very quickly. So that element, that second element of the test, may be much more difficult to implement, which may point the Supreme Court more towards either the verge of insolvency, so an imminent test, or to actual insolvency. I don't know what indication, if any, will have on their thinking it. Maybe that the parties might be called back for some further arguments. But certainly I think the current situation does throw that sort of question into very high relief when the situation moves very quickly in quite extreme ways. But even the information about the state of one's business is harder to uncover.
Yeah, well, thanks, Josh. I don't know, Poppy, if you have anything to add to that.
I can completely agree with Josh that I think the second part of the test, the likely to become insolvent, is going to be more tricky. And I also agree that they may be more inclined to sort of think about being on the verge of insolvency instead.
I mean, thinking beyond the sort of the Bijan Sequana situation, I mean, my sense is that if one had to make a kind of prediction about the effect of this crisis on the way that directors' duties are to be interpreted, is that there's likely to be a wider margin of appreciation in making COVID decisions than might hitherto have been afforded to directors. And of course, save in really obvious cases, it's quite hard to criticise a director in a way that leads to some kind of liability for business decisions. It's easy to identify those which are way beyond the line, but beyond that, the courts and the history of the courts and all the dicta one's familiar with are forgiving in most situations about what directors can legitimately do when faced with a particular situation. And I think that's a trend or a tendency which can only, in a sort of COVID context, even more broadly interpreted, I would say. Anyway, well, that's I think, having made the mistake before of saying there are no questions, I think that wraps things up. Slightly before the hour, I don't think anyone was ever criticised for finishing a webinar or a lecture early. And it just remains to me to thank all of you who have tuned in. And as I say, I certainly set the bar pretty low in terms of what I hope you get out of it and what I'll be gratified that you got out of it. So thank you very much.